Rapporteur of the International Law Association Committee on the Implementation of the Rights of Indigenous People. He has provided several consultancies to Indigenous communities around the world. He is the Delegate of the Rector of the University of Siena of Italy for students and researchers coming from crisis areas, and Director of the Inter-University Center for Research on Human Rights and Immigration Law at the University of Siena. Ladies and gentlemen, I give you our keynote speaker, Dr. Federico Lenzerini. Please welcome.
Can you hear me? Okay, I suppose that everything is in good order. Thank you very much for your very warm presentation. And thank you also for thinking about me for participating in this conference. It is really an honor and a pleasure for me. My presentation is about using international law for promoting reparatory justice for Indigenous peoples and their members in the Caribbean. Please let me share my presentation. Okay. Well, one very important concept when it comes to the lifestyle of Indigenous peoples is the one concerning the circle of life. For Indigenous peoples, the circle of life represents a strong, sacred, powerful symbol incorporating all the basic foundations of life. It symbolizes the interdependence among all forms of life and things, and how all entities move toward their destiny. Reparation for past wrongs represents an essential step in the process of recognition, concretization, and consolidation of the rights of Indigenous peoples within the international legal regime. In the circle of life, which characterizes the existence of most Indigenous communities, there cannot be a decent future if the present has not resolved what went wrong in the past. As regards the concept of reparations or redress, they represent a healing process consisting in curing the wounds opened by the wrongs suffered in the past. These wrongs for Indigenous peoples produce strong intergenerational implications. It is for this reason that reparations are fundamental in view of restoring the order and harmony of the circle of life as existing prior to the wrong. Reparations are decisive in order to guarantee the preservation of Indigenous peoples as distinct cultural communities and eventually the perpetuation of their very physical existence. Now, international law on Indigenous peoples is relatively new. At present, there are three main instruments dealing specifically with the rights of Indigenous peoples. The first one, in chronological terms, is the ILO Convention 169 of 1989 concerning Indigenous and tribal peoples in independent countries. The next instrument is a declaration which is very well known. I'm talking about the United Nations Declaration on the Rights of Indigenous Peoples, adopted by the UN General Assembly in 2007. Finally, the most recent of the three relevant instruments is the American Declaration on the Rights of Indigenous Peoples, adopted by the Organization of American States in 2016. Now, all these instruments have in their text provisions on reparations. As regards International Labour Organization Convention number 169, we have first of all Article 12 stating that Indigenous and tribal peoples shall be safeguarded against the abuse of their rights and shall be able to take legal proceedings either individually or through their representative bodies for the effective protection of these rights. There is no explicit reference to reparations in this provision, but it is clear that it implicitly presupposes a right to reparations for the wrong suffered even though the formulation of the provision seems to exclude that it can be considered applicable retroactively, that is to say, to wrongs occurred before the entry into force of the Convention. However, several ILO committees have recognized that the Convention is applicable to situations occurred much before its entry into force, when past wrongs have ongoing effects which continue to be produced today, and this is the case for most wrongs suffered by indigenous peoples in the past. So this is a very important implication, for the reason that the way of life of indigenous peoples imply, as I previously said, that most wrongs suffered in the past continue to produce implications at the intergenerational level. In ILO Convention number 169, it is also important Article 15, paragraph 2, providing for a right of indigenous and tribal peoples to receive fair compensation for any damages on their traditional lands arising from the exploitation of mineral or subsurface resources present in the territory. Last but not least, Article 16 is important, and it refers to the relocation of indigenous communities from their traditional territories. This relocation is in principle prohibited, but when it is absolutely indispensable, the members of indigenous communities who have been relocated shall be fully compensated for any resulting loss or injury. However, we have to say that at present, among Caribbean countries, only Dominica has ratified ILO Convention number 169. Let us move to the United Nations Declaration on the Rights of Indigenous Peoples. This instrument is plenty of provisions concerning reparations or redress. We have Article 8, paragraph 2, concerning breaches that threaten the cultural identity and integrity of indigenous peoples. Is a very wide article in terms of its applicability, for the reason that it deals with any kind of situation which is suitable or threatening the cultural identity of indigenous communities. According to Article 11, indigenous peoples have also a right to reparation with respect to their cultural, intellectual, religious, and spiritual property taken without their free, prior, and informed consent, or in violation of their laws, traditions, and customs. A right to reparation, according to Article 20, also exists when indigenous communities are deprived of their means of subsistence and development. According to Article 32, a right to redress exists for damages determined by projects affecting the lands or territories and other resources belonging to indigenous communities which determine adverse environmental, economic, social, cultural, or spiritual impact. Last but not least, probably the most important provision concerning reparations included in the United Nations Declaration on the Rights of Indigenous Peoples is Article 28, providing for a right to reparations for the lands, territories, and resources which indigenous peoples have traditionally owned or otherwise occupied or used, and which have been confiscated, taken, occupied, used, or damaged without their free, prior, and informed consent. This provision, as I just said, is particularly relevant for the reason that despite the fact that it was the object of a very vivid debate during the preparatory works leading to the adoption of the declaration, today it seems that there is no reasonable doubts on the fact that this provision is applicable retroactively. That is to say, to wrongs concerning lands, territories, and resources suffered by indigenous communities even before the adoption of the Declaration. This has been confirmed, among others, by the expert mechanism on the rights of indigenous peoples. The preferred means of reparation, according to this provision, is restitution of the territories and resources concerned, but it is not mandatory because we know very well that in some cases it is not factually practicable. I repeat that all the provisions I have referred to are included in the United Nations Declaration on the Rights of Indigenous Peoples, the UNDRIP. And it may be interesting to say a few words on the legal significance of this declaration, because you know very well that differently from a treaty, a declaration is not technically binding for states, even though when the General Assembly of the United Nations decides to adopt a Declaration of Principles, its contents are related to the Charter of the United Nations in some way or other. And so for this reason, there is a very strong moral duty for member states of the United Nations to comply with the provisions of a Declaration of Principles. Anyway, of course, during the history of the United Nations, several Declarations of Principles have been adopted by the General Assembly, and some of them have played a much bigger impact on the development of international law than others. This is the case, among others, of the Declaration on the Rights of Indigenous Peoples, for a number of reasons. First, it has been generally acknowledged as the instrument of reference to define state obligations existing in the field of indigenous peoples' rights, especially by human rights treaty bodies, which in practice have considered some of the provisions included in the Declaration as binding for states. Further, the legal significance of the UNDRIP has been recognized by domestic courts and, in some cases, political bodies of several states. Some countries, including, for instance, Bolivia, the Republic of Congo, and recently Canada, have incorporated the provisions of the Declaration into domestic laws. Others, including, for instance, Ecuador, El Salvador, and Kenya, have modified their constitutions to make them consistent with the UN Declaration. Not to mention the many domestic judgments issued also by Supreme Courts, confirming the legal significance of the Declaration as going much beyond what is commonly recognized with regard to a Declaration of Principle. For instance, just to provide one example, in 2014, the Supreme Court of Belize held that the Declaration obliges the national government to respect the rights of the indigenous Maya peoples to their lands, territories, and resources which they have traditionally owned, occupied, or otherwise used or acquired, and to obtain reparation in the event of breaches. Last but not least, the adoption of the United Nations Declaration on the Rights of Indigenous Peoples has strongly contributed to the formation and consolidation of rules of customary international law concerning indigenous peoples' rights. Among these rules, one concerning right to reparations is to be included. The third instrument to which I have referred is the American Declaration on the Rights of Indigenous Peoples, which also includes at least 4 provisions concerning reparations and redress, very similar to some previously included in the UN declarations. As regards customary international law, You know that it is particularly important because when a provision of customary international law exists concerning a given topic, it means that it produces obligations for all countries in the world. Of course, they are not obligations of absolute character, but unless there is a very strong reason allowing a state to derogate from them, there is a legal obligation for all countries to fully comply with provisions of customary international law. Among these provisions, it has been recognized, for instance, by the International Law Association Committee on the Rights of Indigenous Peoples and the UN Permanent Forum on Indigenous Issues, that under customary international law, indigenous peoples have the right to reparation and redress for the wrongs suffered. And this right, as I previously said, amounts to a rule of customary international law to the extent that it is aimed at redressing a wrong resulting from a breach of a right that is itself part of customary international law. So a right to reparation exists inherently, for instance, when there is a violation of land rights, or right to self-determination, or right to autonomy and self-government, which are also sanctioned by rules of customary international law. This is for the reason that redress is an essential element for the effectiveness of human rights. In particular, it has been recognized that states must comply with the obligation, according to customary international law, to recognize and fulfill the right of indigenous peoples to reparation and redress for the wrongs they suffered, in particular when their lands have been taken or damaged without their free, prior, and informed consent. Effective mechanisms for redress established in conjunction with the peoples concerned must be available and accessible in favor of indigenous peoples. Now, so far I have shown the existence of a number of rules, both of treaty, soft and customary international law. Of course, you know very well that for a rule to be effective, it is not sufficient that it is written on a legal instrument, for how important these legal instruments may be. The most important thing in order to make a rule, especially in the human rights field, effective in the life of people, is that they are concretely applied to situations involving real human beings, in our case, real indigenous communities or their members. I would like to emphasize that human rights treaty bodies established by both treaties adopted by the United Nations and by regional treaties have recognized through an evolutionary interpretation the existence of a number of rights of indigenous peoples corresponding to obligations for the states parties to the relevant treaties, even though in such treaties there are no explicit mentions to indigenous peoples themselves. And this is very important because human rights treaty bodies have shown to be sensible to the importance of guaranteeing the effective enjoyment of the rights of indigenous peoples. So, for instance, the Human Rights Committee, established by the International Covenant on Civil and Political Rights, adopted in 1966, has recognized that an obligation of states parties to the covenant exists to provide an effective remedy and reparation measures for violations of land rights. And these measures must be commensurate with the harms sustained and must take the form of the necessary measures to ensure that similar violations do not occur in the future. In addition, there is an obligation of the states parties to the Covenant on Civil and Political Rights to adopt legislation designed to guarantee the full enjoyment of all indigenous peoples' rights under the Covenant, including the restitution of communal lands. Another committee which has taken a similar position is the Committee on the Elimination of Racial Discrimination, established by the International Convention on the Elimination of Racial Discrimination, adopted by the United Nations in 1965. According to the committee, states parties to the convention are under an obligation to take steps to return to indigenous peoples the lands and territories traditionally owned or otherwise inhabited or used, of which they have been deprived without their free and informed consent. Only when restitution is not possible for objective factual reasons, the right to restitution should be replaced by the right to just, fair, and prompt compensation. Such compensation should, as far as possible, take the form of lands and territories. This position was taken by the committee already in 1997. More broadly, the Committee on the Elimination of Racial Discrimination has recently recognized a right to indigenous peoples to an effective remedy, for instance, when, in all cases in which the free, prior, and informed consent has not been obtained by states before doing any activity which may result in a damage for the indigenous community concerned, and more generally when the right to self-determination and the autonomy of an indigenous community has not been recognized and has not been respected. At the regional level, the jurisprudence of the Inter-American Court of Human Rights, established by the American Convention on Human Rights of 1969, emerges, and it is needless to say that this is particularly important for the territory of the Caribbean. Now, in my modest opinion, the practice of the Inter-American Court of Human Rights concerning reparations is probably the most advanced in the world. This is for the reason that the court pays particular attention to the collective dimension of reparations for indigenous peoples. In addition, it pays attention to ensure that the forms of reparations guaranteed to indigenous communities following violations of their rights will be able to effectively redress the damage suffered according to the perception of indigenous peoples themselves. So, when situations of violations of land rights occur, the court is used to recognize a number of different forms of reparations, all referring to the idea of the restitutio in integrum, restitution, which translates, among others, into the following. First, restitution and legal recognition of the community's collective ownership rights to the traditional lands and resources in accordance with their customary law, values, and usage. Secondly, collective title to these traditional lands and resources that confirms and effectively secures their ownership rights in accordance with their customary law. Third, physical delimitation and demarcation of the lands concerned. Fourth, guarantees of safety for community members inhabiting the lands concerned. And fifth, full participation and informed consent of community members in establishing the preceding measures, the measures that I have referred to in the previous point. But the significance of the practice of the Inter-American Court of Human Rights does not stop here, for the reason that in several cases the Inter-American Court of Human Rights has also recognized a number of measures of symbolic reparation, better said, satisfaction in favor of indigenous peoples victims of violations of their rights. So these measures are a lot. I will mention the principal ones, and they include appropriate investigation concerning the facts of the case, public acknowledgement of responsibility, publication and dissemination of the judgment or a part of it in the language of the community concerned, broadcasting of the judgment or parts of it, usually via radio, erection of a monument to memorialize the violation suffered, formal apology, establishment of developmental funds, no repetition guarantees, and adaptation of domestic legislation to the relevant rules of the American Convention of Human Rights. A similar approach, which has very much been inspired by the jurisprudence of the Inter-American Court, has recently been followed by the African Commission on Human and People's Rights, established by the African Charter on Human and People's Rights. The Commission, especially in two cases, one concerning Nigeria, 2002, and one concerning the Endorois community in Kenya, the communication was released in 2009. The African Commission has recognized the right of indigenous communities to a number of reparations of the same kind of those recognized by the Inter-American Court. Especially in the most recent case, the Commission held that there was an obligation of Kenya to recognize rights of ownership to the indigenous community concerned and restitute their ancestral lands. Ensure that the community members have unrestricted access to their traditional lands and surrounding sites for religious and cultural rights and for grazing their cattle. Another measure of reparations consisted in paying adequate compensation to the community for the loss suffered, and also an obligation for the state to pay royalties to the indigenous community arising from existing economic activities carried out in their traditional lands. Very recently, in 2022, a similar position was taken by the African Court on Human and People's Rights, that, as you know, was established by a protocol to the African Charter on Human and People's Rights adopted in 1998. And of course, the jurisprudence of the court is particularly important in Africa because its judgments are binding for the respondent state. And in a case also concerning Kenya, the court recognized the right of the indigenous community concerned to receive pecuniary compensation for the material damage suffered by the community. Pecuniary compensation, in addition, for the moral damage suffered by the community. Obligation for the state to take all necessary measures, legislative, administrative, or otherwise, to identify, in consultation with the indigenous community concerned, and delimit, demarcate, and title ancestral lands, and to grant collective title to such land in order to ensure with legal certainty the use and enjoyment of such lands by the community. In addition, the court requested the respondent state to guarantee full recognition of the community concerned as an indigenous people, take all necessary legislative, administrative, or other measures to recognize, respect, and protect the right of the community to be effectively consulted in accordance with the traditions in respect of all development, conservation, or investment projects on its own ancestral land. Finally, the court recognized the existence of an obligation of the state to establish a community developmental fund for the community concerned, which should be a repository of all the funds ordered as compensation in the case. So, before coming to my conclusion, I would also like to mention the Caribbean Court of Justice, which is particularly relevant. There is a judgment of 2015 concerning the land rights of the Maya people of Belize. And even though in that case the court was unable to recognize compensation for pecuniary damages suffered by the community, because according to the court, these damages cannot be ordered when they cannot be specifically proven, it recognized the right of the community to reparations for moral damages, taking into account the distress and suffering of the community arising from their violations of the core values and of their special relationship with their ancestral territories. And so a number of practical measures of reparation was necessary. My conclusion: what kind of recommendations could be formulated for indigenous communities in the Caribbean in view of improving their access to reparatory justice? First of all, make pressure on governments to persuade them to ratify ILO Convention 169. We have seen that the convention includes a number of provisions of reparation, but so far among Caribbean countries, only Dominica has ratified the convention. Make recourse to judicial bodies at the national and regional levels, including the Caribbean Court of Justice, which have proven to be receptive with regard to instances of indigenous peoples. Third, and particularly important, it is necessary, when possible, to make recourse to international human rights treaty bodies. We have seen that they have developed an evolutionary interpretation of human rights standards which is totally receptive of the rights of indigenous peoples, and in many cases they have translated this interpretation into the recognition of concrete obligations for the state to recognize such rights, especially when it comes to reparations for past wrongs. Last but not least, any kind of activities should be developed for the promotion and recognition of rights of indigenous peoples before governmental and other national institutions, NGOs, and the civil society. This was my conclusion. Thank you very much for your attention, and again, thank you very much for inviting me to participate in this very important event.